session.
Hi, good morning. Welcome to the Court of Appeals. We have 4 matters calendared for consideration today, and in one of those, oral argument, and that is the case of Wilson versus Wilson, our case number 2021-0855. If we could first have counsel enter their appearances.
Michael D. Stanger, on behalf of the appellants and cross appellees, TKS Copac Manufacturing and Troy Wilson.
Thank you, Mr. Singh.
Good morning. Brady Brammer on behalf of appellee and cross appellant, Doug Wilson.
Thank you, Mr. Bremer. We have 2 appeals here this morning, which I understand we then, each side would have 20 minutes to argue, and we can divide that if you've already decided a way to divide that. But ordinarily, we would hear from the appellant, and then we'd hear from the other appellant, and then rebuttal and more rebuttal limited to the cross appeal. It looks like you've reserved 5 minutes.
That's right.
Okay. Mr. Brammer, how do you intend to proceed?
5 minutes as well.
Okay. We just invite you, for the sake of those who may be listening online or listen to the recording later, to re-enter your appearance as you come to the podium each time. And if there aren't questions, you can proceed.
Thank you, Your Honors, and may it please the court. My name is Michael D. Stanger, appearing today on behalf of the appellants and cross appellees TKS Copac Manufacturing LLC and Troy Wilson. Focusing first on our appeal, a stalking injunction that can be violated without consequence is of limited utility to the stalking victim, in that it does not provide the safety and peace of mind that was sought and theoretically obtained. And there are several bases on which we've challenged the district court's decision not to find Doug Wilson in contempt of the stalking injunction. I'd like to start with the concept of the requirement that a stalking injunction or an act of stalking needs to be distressing to a reasonable person in the victim's circumstances. In this case, that would be in Mr. Troy Wilson's circumstances. That's quite clear from the statute itself. The statute commands the court to consider the impact on a reasonable person in the victim's circumstances. That's at Utah Code annotated 76.5, 106.5, 1A4. And both this court's precedent and the precedent of the Supreme Court track that logic and tell litigants that a court should look at.
What is your challenge to that particular part of the district court's ruling? Are you challenging the district court's factual determination as to the level of emotional distress a reasonable person in that position would have suffered? Or are you making some sort of legal challenge to the standard that the trial court used?
Well, I think it has both factual and legal components to it, Your Honor. First, I guess regarding the immediate acts surrounding the Facebook posts and the communications with the customer, we believe the district court erred when it refused to consider highly relevant evidence of Troy's circumstances in the short term.
Let me just back up and make sure my question is clear. Are you asserting that the district court did not use the individualized objective standard?
I don't believe it did because of the evidence that it refused to consider. It took the acts in isolation rather than considering the circumstances in which Mr. Troy Wilson found himself.
All right, but on page 4 of the court's ruling, the court did note that it's looking at this through the lens of whether a reasonable doubt exists as to whether a reasonable person in Troy Wilson's position, rather than just any inordinately sensitive person, would suffer emotional distress. It looks like the individualized objective standard was front of mind for the court.
Well, the court certainly
tell me why that's wrong.
Well, the court certainly gave lip service to the language of the statute, but if you look at the evidence which the court excluded as part of its determination of what a reasonable person in Troy Wilson's circumstances would feel, it's clear that the court was not concerned about Troy Wilson's circumstances as a whole.
Although
Right.
the court did exclude evidence of why the stalking injunction was imposed in the first place, it did say that it was taking judicial notice of those prior proceedings. And it appears that in the record, though, that those proceedings are in the record by transcript. So although it didn't hear directly that evidence, it did have that evidence. And why is that not sufficient?
Well, if the court had actually taken those acts, taken judicial notice of those acts, one would expect to see some analysis about how the earlier acts impacted Troy Wilson as he received notice of the Facebook posts and or the communications with Mr. Christensen. So I agree. The court did say, hey, I have judicial notice. I'm taking judicial notice, but that was a full day's evidentiary hearing with significant documentary evidence. I just don't see the court engaging anywhere with the actual record. So to the extent.
The court, at least, one would expect, would have said, I've considered those, the transcript from the prior hearing, as I said I would. I just don't see that it's germane at all. Or made some other comment. But to pay lip service to the idea, okay, judicial notice, yeah, and then do nothing with it, is problematic in your view.
It is problematic because there was significant water under the bridge, and we have no discussion of how that water under the bridge impacted Mr. Wilson. Rather, we just see a discussion of how the Facebook posts themselves would impact a normal person. We don't have an analysis of Mr. Wilson's circumstances in which he found himself. I think even setting aside the issue of whether the prior proceedings were taken into account, Mr. Wilson's circumstances were disregarded when the court refused to consider the declaration of Rob Wilson, the testimony of Rob Wilson, and the significant testimony he provided on the conversation Mr. Rob Wilson had with his brother Doug Wilson at or about the time of the posts.
Well, help me understand the extent to which you think the court refused to consider the testimony of Rob Wilson. Because Rob Wilson did testify at the hearing, right?
Yes.
The court heard him testify. So help me understand why he didn't, or how he didn't consider the testimony of Rob Wilson.
Well, the court in its order says, after announcing that he's going to use a reasonable doubt standard to consider the evidence, says the court finds that all of the witnesses from the Wilson family possess such significant biases that the court cannot credit any of their testimony beyond a reasonable doubt. And then the court provides no foundation for that conclusion, doesn't engage in any particularized analysis with respect to individual Wilson family members. There's no explanation of what Rob Wilson's alleged bias is, and no engagement with the statements of Rob Wilson in the order. I mean, take into account, Rob Wilson tells us that Doug Wilson's statements about the purpose of the Facebook posts was to make clear to the readers that Troy Wilson was a thief, a criminal, to make him feel pain and suffer, to destroy Troy and his business and character. Those are the kind of things you would expect the court to see the court analyzing in the context of whether a reasonable person in Troy Wilson's circumstances would feel distressed. But it appears more that the court simply used the reasonable doubt standard as a reason to exclude that highly relevant testimony rather than engage with it.
You just used the word exclude, and I'm curious there. It seems like the court made a credibility determination, a sweeping one, admittedly, that no
That's probably a
no
more fair
family
statement,
members
Judge. Yeah, that's probably a more.
That he did admit the evidence, made a credibility determination, a sweeping credibility determination. And as the fact finder, it seems like the court can determine credibility. Is your argument really that there's not adequate findings explaining why the court exercised its role as fact finder there, or?
Well, that certainly would dovetail with the argument I've just made. I mean, if we're going to make credibility determinations, there should be some analysis on which to base those. And really, he doesn't say, I find Rob's testimony irrelevant. You're right. He doesn't say this is a 401 analysis, but he does say, because of the reasonable doubt standard, that's the reason I'm not going to consider this evidence in.
But
in,
you're not arguing that the court as fact finder couldn't make credibility determinations, even if it's as to every familial witness?
Well, I think that would be a bridge too far to make an argument like that. Of course, that's the role assigned to our trial court judiciary, is to, when they're sitting as a fact finder, is to make credibility determinations. But those credibility determinations need to be based in the rules of evidence, and based in adequate findings. And we just don't have those here. What it looks like is, as you've called it, a sweeping credibility determination without any particularized analysis of why particular siblings' testimony.
In my experience, it's quite rare. I mean, we see it occasionally when a trial court will go on to explain why it found this witness or that witness not credible. But the vast majority of credibility determinations, the court just says, I find this witness incredible, or these witnesses incredible. And typically, additional explanation isn't offered, and appellate courts assume that this is based on all manner of circumstances that we're not privy to, some of which social scientists will question, but manner and bearing and the countenance of the witness and the background and the context and all the rest. So I'm not sure that we would ever look beyond an explicit credibility determination, sweeping or otherwise, to see what facts support that determination.
Well, Your Honor, and I would agree that most frequently that is the case, that such a ruling is going to be terse. It's going to be pronounced from the bench. We have a written finding of the lack of credibility here, not bolstered by any factual findings. I think that makes a difference, particularly when the court does actually provide some justification, and that justification is the reasonable doubt standard that he's looking to, and not any evidentiary basis.
I don't read it quite that way, and wonder if you could explain that. The reason I don't read it that way, there's the one paragraph where the court says, to establish a violation of the order, petitioners needed to establish beyond a reasonable doubt that Doug intentionally violated the order. The court just says the standard. In the end, the court concludes that it cannot make any findings beyond a reasonable doubt. More specifically, the court finds that all of the witnesses from Wilson family possess such significant biases that the court cannot credit any of their testimony beyond a reasonable doubt. Seems that the court is explaining that it's credibility determination that leads it to conclude that it can't make a determination beyond a reasonable doubt, not the other way around, as you're suggesting. How does that language tell us that, I've decided, because I know I've got to decide this beyond a reasonable doubt, I'm just going to disregard everybody, all the family witnesses, as not credible? It seems like the analysis was the other way. I don't believe they're credible, and therefore I can't find beyond a reasonable doubt.
Well, I think we've both presented potential readings. I'm not sure we know, but we do know that the statute and our precedent command us to look at the acts not in isolation, and that the result of the court's ruling was to look at these acts in isolation, which, notably this same district court judge, as I pointed out in my Rule 24J letter, was just admonished by this court to not do that. In the Anderson v. Deem case, this court said, we direct the district court to avoid looking at whether each of Deem's individual acts induced fear or caused emotional distress, instead focusing on the impact of the overall course of his conduct on a reasonable person in Anderson's circumstances. the result we have of his excluding Rob's testimony is that we are looking at those acts in isolation without important context. I mean, the context there provides let's assume Rob was wrong and had misremembered. Troy still was told by Rob what those statements were. And so this is not just evidence of Doug's intent, which is, I think, what the court was looking at it for, but this is evidence of what Troy had been told about Doug's intent. And so Rob could be biased, but his relating that information to Troy still colors Troy's understanding of Doug's intent and colors the question of what a reasonable person in his circumstances would have understood about.
If for whatever reason, assume hypothetically for the purposes of my question that for whatever reason we end up deciding that we need to affirm the district court's determination about emotional distress, can you still win your appeal? Is that a necessary condition for you to win your appeal, to persuade us that the emotional distress finding was error?
I don't think so, because any violation of a stalking injunction is contemptible. And so just the straightforward discussion with Mr. Christensen is a straightforward violation of the injunction. By communicating.
Okay, so let's get down to the nitty-gritty of the order then. So if we were to affirm the emotional distress finding, that would mean there ipso facto is no violation of paragraph 3 of the order, right?
Remind me which paragraph 3?
It's the one that says Doug is not to stalk Troy.
Yeah, it also says he's not to communicate with customers. So,
Well,
yeah, there would be,
that's the next
different
paragraph.
Yeah.
So we'll get there. I just was hoping for your agreement for the purposes of our discussion that if we affirm the emotional distress determination, there cannot be a violation of paragraph 3 of the order. Is that right?
Of that particular paragraph, yeah, I think that's probably right.
Because emotional distress is a necessary condition of stalking, and if that's not true, then there's no stalking, therefore there's no violation of paragraph 3.
Right. I mean,
Okay.
if this was just a simple statement by Doug that, I have a brother named Troy Wilson, and the court had said, nobody would find that
So
emotionally distressing.
tell me exactly how you think paragraph 4 was violated here.
That's the one with the discussion with the customer?
It says Doug must not contact or communicate with, either directly or indirectly, in any way with Troy and any other person listed below, any customer of TKS.
Right. And I know that my time is up. Do you want to cover that on?
No,
You
I
want
want
to-
you to answer it now. As long as we're asking you questions, the clock is irrelevant.
Okay, just making sure. So our contention is that it was very clear that was a very clear violation because Derek Christensen was a customer. The evidence that was presented at the initial hearing was that Doug's employer had appointed a separate person, Annette Roylance, to be the point of contact, just for the purposes of avoiding the need for those communications. That Doug knew Mr. Christensen was a customer from the time he spent employed at TKS, and that there were 3 or 4 times that Doug had communicated with Derek after entry of the stalking injunction. There's no suggestion in the language of the injunction that it has to be a current customer, and I think,
Well,
that's.
so the court's finding on that point is on the very last page of the order, and that is, there's reasonable doubt about whether Doug intentionally violated the order or whether he merely attempted to comply. So I guess your argument would have to be that it is not a permissible reading of the evidence to find that Doug was just trying to figure out if Derek Christensen was still a TKS customer?
Well, no, I think there is some evidence to show that he was trying to comply, but that could also be read as gamesmanship. I mean,
It could, but
Yeah.
that's a factual finding we would presumably have to defer to, wouldn't we?
but the evidence is that he communicated with a customer.
So your position is, if Doug contacts someone he doesn't know as a customer and says, hey, are you a customer? That is necessarily right there a violation of the order.
Well, in order to be a current customer of McDonald's, I don't have to have a hamburger in my mouth. And so the fact that I go there on a repeated basis makes me a customer. And so there's no reasonable reading of the evidence that Doug didn't know Derek was a customer. In fact, he's reaching out to Mr. Christensen after we filed a motion for contempt, saying, hey, I've been accused of violating the order. Can you just tell me the last time you did business with TKS? So he knows that they've done business. He wants to know when the last time was, because he's trying to put a gloss on the order that isn't there. He's trying to put this current customer
Well,
gloss.
to use your McDonald's example, I mean, let's say that I went to McDonald's once and I had a McRib and I thought it was the foulest thing ever, and I said that I'm never going back there again. You can decide to not be a customer of something at some point, right? And so if there's truly doubt about whether he's still a customer, you're saying he can't ask. And if he does ask, that's right there a violation. That's your position?
Well, I think one reason that the court is struggling with this is because, or that the court did struggle with this is because of the nature of the relationship, being a customer relationship. I mean, would you have the same position if Doug had called Patty Wilson and said, hey, Patty, I just want to make sure, are you currently, married to Troy? Because otherwise I'd really like to talk to you. I mean, essentially, this is kind of a no harm, no foul analysis from the district court, and that's appropriate in basketball. That's not appropriate in the context of a stalking injunction.
Okay, so back to my question about paragraph 4. Is that the only way you think paragraph 4 was violated, namely these communications with Mr. Christensen
That was the only basis of our motion for contempt
on paragraph 4?
on paragraph 4.
Was the Facebook post not a paragraph 4 violation indirectly communicating?
Yeah, I mean,
That was my question.
Yeah.
Apparently, it says today the position is no. Is that your position?
no, I mean, focusing just on the Facebook post, yeah, that's a paragraph 4 too, because the lengthy list of Facebook friends, which we presented in the record, included several family members, communications to and about Troy. I mean,
Well, right, but there's a difference between paragraph 4's what it forbids and what the stalking injunction forbids, or a stalking statute forbids. That is the word about. You just used the word about. Stalking talks about communicating about someone being
Right.
potentially violative of the statute. Paragraph 4 doesn't use the word about.
Yeah, that's the no
It says-
contact order.
It says with.
Right.
And so a Facebook post may be communicating about Troy, but is it a clearly erroneous factual finding for the court to determine that that wasn't an attempt to communicate with Troy?
To indirectly communicate with Troy, I think that is clearly erroneous. I mean, all the evidence was that this is a family where very close sibling relationships resulted in a lot of communications between and amongst the siblings. The evidence was that, in fact, Troy was communicated with through this
So,
post, that several people
by that
within
logic-
minutes of the,
By that logic, would Doug ever be able to discuss this and anything about this situation with any member of his family? Or are you saying that any discussion about this dispute with any member of the family under any circumstances is a violation of paragraph 4?
so I guess the question then would be, if Doug were to communicate, to use a communication with a family member to communicate with Troy, right? So,
Well, if Doug said to another sibling, hey, I'm really mad at Sarah, I think Sarah lied on the stand, and on, basically the same content of the Facebook post, if he said that to another sibling privately, do you think that would violate the stalking injunction?
well, by communicating with Troy,
Right, indirectly with Troy.
indirectly with Troy. Yeah, I think,
I'm trying to
that's a-
probe what the difference is
what the-
between
you're-
the Facebook post and just, hey, call up another sibling and express displeasure with the situation. What's the difference there legally?
well, social media is certainly a more scattershot type of communication than the targeted communication with the sibling. I mean, this post was promptly seen by many different people, several of whom
What about a
called.
family email chat that doesn't include Troy? Includes 3 or 4 of the other siblings?
And says
The same thing.
says the same thing about, yeah. I think Doug could probably reasonably anticipate that would get back to Troy, that would be communicated to Troy. I guess it would depend on the individual siblings, what he knew about their relationships.
Right, but
with
even
Troy.
the private conversation, Doug could reasonably anticipate that that's going to get back to Troy.
Right.
If that's the standard, this is what I'm probing with you.
Mhm.
If that's the standard, that any communication that Doug could reasonably anticipate would get back to Troy, if that equals communicating indirectly with Troy, then that means this order forbids him from saying a dang word to his entire family about this situation ever, right?
I think that's why the emotional distress clause is important.
But there's
From
no
3.
requirement in paragraph 4 that there be emotional distress. That's only in paragraph 3. So
Right.
if you're saying that paragraph 4 forbids any communication with family members about this, I'm just trying to make sure that I understand your position. And I think that is what your position
I think that has to be the position, and I guess stalking has consequences, and that doesn't prohibit Doug from having all manner of other communications with his family, and
Just not about the number one topic this family wants to talk about.
well, I don't know if there's any evidence in the record to say that they're really
All right,
excited
fair enough.
about this matter.
I wrote an opinion, I want to say a few months ago, but my sense of time is not as good as it once was, where we upheld a determination that a stalking injunction had been violated, where an ex-husband communicated not with his ex-wife, who he was precluded from communicating with, but with her sisters. But there was the additional factual finding and context that he knew or should have known one of the sisters lived with the ex-wife, and the court found that he well knew that the sister would have shared with his ex-wife the contents of the letter, and that did happen, in fact. But we don't seem to have a similar kind of link it up finding here. I mean, you say the implication is, or it's a fair inference that it would get back to Doug, but I'm not sure that should be left for inference. If I'm recalling this other case correctly, the court explained why that was a violation. Yeah, it didn't go to her, it went to the sister, but that was indirect communication and violation of the injunction because he well knew the information would have been shared.
Right, and we're not asking that to be left to inference either. What we've got is what actually happened, and that is that when the Facebook post was made, within minutes, Troy was receiving phone calls from common acquaintances who had seen the post on Doug's Facebook wall and were concerned about the implications of the post.
And you think that after the fact, evidence of what happened can properly inform what Doug would have fully expected in making the post?
Sure, particularly when coupled with his statements to Rob that he intended the posts to harm Troy.
Do we need to, is there a mens rea requirement with regard to paragraph 4? Like if you're asking a court to hold somebody in contempt, there has to be intent, right? As opposed to finding somebody in violation of the stalking statute initially.
Right.
Intent's not really, I mean, there's this individualized objective stuff and there's, we don't, maybe the Counterman case in the Supreme Court this term is going to change all this, I don't know. But at this point, the stalking statute doesn't require intent in the same way that a finding of contempt does. Do you follow me?
I think that's right. I think that in the broader universe of contempt jurisprudence, it's pretty universal that
Right,
in
and
order
here-
for someone to be held in contempt, they have to know what was expected.
Yeah, and so here, the court has to find that Doug intentionally violated paragraph 4. Do you agree with that?
They intentionally violated paragraph 4, yeah.
So Doug would have to know or intend that his communication be an indirect communication with Troy.
Mhm.
And if the trial judge found that he didn't have such intent, we would need to defer to that?
If the trial judge found that he didn't have such intent,
In other words, that he put this out on Facebook, not necessarily intending that it be a communication with Troy.
right. I think the best evidence there is again, Rob Wilson's testimony that Doug told him the purpose of these posts was to inform everybody that Troy was a thief and a liar and to harm Troy, et cetera, et cetera. So, yeah, I think,
And the trouble there is that the court made a credibility determination about Rob and everybody else.
right, but he didn't make a credibility finding about those actual statements. He didn't actually address those statements. He just said he's not credible because he's a Wilson family member. He didn't engage with the statements which went to the heart of Doug's mens rea. So that's where we've got a decision that seems to be against the great weight of the evidence, that the only evidence of Doug's intent was his statements to Rob and his own denials, and the court, didn't seem to want to engage with why Doug should be credited above Rob. Rather, he just excluded any consideration of Rob's testimony under this reasonable doubt standard. And I know you've taken issue with me using the exclusionary language, but he certainly excluded any analysis of it from his opinion when he used the reasonable doubt standard.
Okay. Mr. Brown.
May it please the court, Brady Brammer, representing Doug Wilson as appellee and cross-appellant. So I want to focus a little bit on the first issue of the cross-appeal, specifically the issue of the specific individual language in the statute, as well as the application of the civil stalking injunction statute in this circumstance. Now, and whether that original civil stalking injunction was granted appropriately. So we're kind of shifting gears from the contempt proceeding to the original proceeding as to the issuance of the civil stalking injunction.
Can I ask you about the original civil stalking injunction's expiration date?
Sure,
It expires about 6 weeks from now, right?
correct.
And look, I like to get opinions out as fast as the next guy, but I would view it as unlikely we're going to get an opinion out in this case in 6 weeks' time. What happens to the stalking injunction on October, is it the 23rd or the 29th?
It will
Somewhere.
expire of its own accord.
Doesn't that moot your challenge to the propriety of the stalking injunction itself?
No, it does not.
Tell
And
me
the
why.
reason why is because there are certain civil repercussions for an improper stalking injunction, for him being enjoined from various actions throughout that entire time. And this was devastating to him. It alienated him from his entire family. It caused him to attempt to commit suicide. There were a whole host of damages that flow from that. And statutorily, if this was granted incorrectly, then all of that goes back to the district court to be determined. Additionally,
What
from-
kind of damages are you talking about? Just help me understand.
well, all of the attorney's fees, first of all, if it was granted incorrectly. That's by statute, that goes back to the district court to determine those attorney's fees could be awarded to him for an improper civil stalking injunction issuance. Now, but
Has
additionally.
there been an award of attorney's fees yet?
No, that would have to be, if the civil stalking injunction is found to be improperly granted later on, then under the civil stalking injunction statute, those damages flow back and it would cause attorney's fees. But the more important issue is there is a very huge legal issue that will have huge implications on a reported decision like this moving forward. And that is, what is a specific individual? Now, additionally, it is the standard of what a reasonable person could be emotionally harmed by. And so even though the expiration could render the impact moot, the issues as to whether this was correctly decided have huge implications. And let me explain why. Now, the first issue is the judge here concluded that he was, quote, satisfied to a preponderance that there was a course of action, that it was directed in such a way that although it was aimed at the company, it was aimed at the company in a particularly harmful way, and that satisfies the requirements of the stalking injunction. Now, aimed at the company, so the civil stalking statute talks about the
I want to
That-
pose a hypothetical, and this is
Sure.
maybe stereotypical, but it's helped my thinking. Let's say that instead of a two brothers relationship, we had the more stereotypical stalking, a boyfriend who gets dumped and now wants to stalk? What if the boyfriend said to the now ex-girlfriend, sister, I'm going to ruin her? And she teaches piano lessons. And he then starts contacting her piano lesson students and their parents with kind of creepy stuff. It seems like that's exactly what stalking is meant to prevent. How is that distinguishable here? Contacting the sister and saying, I'm going to ruin him, and then contacting business customers with kind of creepy stuff.
Well, first of all, you have to decide what is creepy stuff. I think that's a really big factual part of this.
That's
So-
not a familiar
that's
term
really-
of legal art to you?
So-
And actually, the statute
Well-
doesn't call for creepy stuff. That to me seems to go to does it cause emotional distress?
So-
The statute just says contact coworker. Do we not have contact with a coworker here? Because first you figure out, do you have a course of conduct? We've got, I'm gonna ruin him, and then I contact coworkers. Isn't that a course of conduct, and we then move to, would it cause a reasonable person emotional
Well,
distress?
any two actions can be a course of conduct.
Exactly.
Okay, now, but that's the easy hurdle. The harder hurdle is a little different. So let me flip your scenario a little bit. Let's say that I have a problem with Elon Musk. And we're gonna say that it's Twitter instead of X, because that doesn't make any sense. So if I say, I'm going to ruin Elon Musk by suing Twitter, by reporting them to regulatory agencies, by doing things that will cause civil liability to Twitter, would that be enough to cause emotional distress? And did the legislature intend that threats of civil liability or reporting of civil action amount to emotional distress? And so we have to go to the statute and look at it. No court in Utah has ever found that an entity, that actions directed at an entity amount to emotional distress.
Well,
So
couldn't
you've moved to, I'm just wanting to make sure I'm tracking. You've acknowledged a course of conduct, it seems, and have moved on to
Well,
emotional distress.
I've acknowledged that a course of conduct is any two or more items. Now, it has to be two or more items that are threats to a specific individual or are sufficient that a reasonable person would have emotional distress under 106.5 of the stalking
or
statute.
doesn't it also say or are directed at?
Directed at-
Well, it says actions directed at that would cause
Yeah.
a reasonable person to be threatened for, so
And so the directed at language seems to me like if he says, I want to ruin
Yeah.
Troy, and then directs a bunch of acts at Troy's company in an effort to ruin Troy, couldn't a court find that those acts are actually directed at Troy personally because the best way to ruin Troy is to ruin his business? I mean, that would be dependent on the facts of the case, right?
Well,
Couldn't the
let-
trial judge so find?
I think this court is going to have to determine what the legislature intended on this. And what I mean by that is, when they say directed at an individual person, what does that mean? Okay, now,
Didn't Ragsdale answer that?
Ragsdale did not address that, but they addressed it in footnote 29. They said, we're not getting to that, but there is an important distinction in Ragsdale, and it's really pretty fascinating. So they said in footnote 29, one state has found that under their statute, it could be interpreted to mean corporations or LLCs, and that's Wisconsin. But when you go to the definition of what happened in that case, it's the Decker decision. In that one, what they said was, they used the language, not individual, not specific individual, they used person. And they say, because in our other areas of code, in Wisconsin statute, person is defined to include corporations, partnerships, LLCs, joint trusts, that kind of thing. We can assume that the legislature intended that person, under the Wisconsin statute, would also include those here.
But
But-
isn't the analysis that you're giving us right now really going to the question of whether an entity can get an injunction?
Not necessarily. Here, the finding was that it was directed at the entity. That was the finding of the court. It was directed at the entity. And I'll get to the issue of, let's assume that it's directed at Troy, okay? So I promise I will get to that.
That was my question, is if the
Yeah,
court
so-
could find that an action taken toward a company was actually directed.
Yeah, so, and I think that's fair, and I want to analyze that, but I do think we need to get to the statutory issue here of, in Wisconsin, they said because the statute used person, and that's defined to include those other entities, that it's fair to include entities in that. In Utah, we also use the term person, and it includes other entities, but but the legislature did not include the term person here.
Used individual.
It said, and not only individual, it said specific individual. And later in the statute, when it's talking about what it would be, it actually says the individual's own safety, not necessarily the safety of their entity, but their own safety. And so essentially what we get at is, I don't think that there's a reading where we can include entities, issues directed at entities as being within the purview of the statute. Now, to the question of, okay, let's say that it could be found that it was directed at Troy individually. We have to look at whether threats of civil liability that could ruin someone are within the purview of the statute that would cause emotional distress. Okay, so let's look at each of the instances. There's the discussion with his sister Sarah, where he says, I will sue him. I think I have a cause of action. I will contact customers. I will bring the company down. They will lose business. They'll lose everything. I will sue at the most expeditious time. Now, if that's improper, there are measures to prevent behavior of tortious interference, and that's an injunction, a Rule 65A injunction. It is not a civil stalking action. When it says, I'm going to do harm to your business. So that's the first one. And all of those threats are civil threats against the company. Now, it may impact Troy, but threats of civil liability against a company, is this court prepared to say that threats of civil liability against a company are enough to satisfy the civil stalking action, the civil stalking injunction? That's a really big leap and a really big change in our jurisprudence related to civil stalking injunctions. It turns it into a tool for every civil litigant. Now, the second thing was a text from one TKS to a TKS employee that said, what are you talking to her about? It didn't involve Troy. There was no threat. It just said, what are you talking to her about? Okay, I don't think that, and the way the judge looked at it is he said, that creates an all-knowing sense. Well, he's a former employee who works as the property manager. He does know a lot about the area, and he's texting someone and saying, what are you talking to her about? Now, the last one is a business conversation with with an employee about how TKS was mishandling their product. Again, that's a civil issue. And now, is this court really prepared to say that instances of civil threats to a company amount to what a reasonable person would consider to be emotional distress? So, for example, if I write the mean lawyer letter to someone and say, we're going to sue you for this, this, and this, and I do it 2 to 3 times, is that enough? Or are we only saying that as long as you have the veneer of professionalism for attorneys, threats of civil liability are okay, but if you don't have the veneer of professionalism for an attorney, threats of civil liability now amount to potentially civil stalking?
The attorney wouldn't typically write in the cease and desist letter, if you don't cease and desist, we're going to start contacting your employees and interfering with your business. And it seems that maybe the legislature, where it didn't speak explicitly, may have intended that there is a difference between cease and desist, and if you don't, we're going to begin tortious interference.
I don't think a civil stalking injunction is meant to prevent tortious interference.
So was there a judicial proceedings privilege defense here?
There was not, well, there was in the sense that this was all done on an ex parte basis, and the civil stalking injunction was entered before
Right.
Doug knew anything.
Right.
And in fact, part of the reason why this is a big deal is it's not like he made these statements all in a row and then they filed the civil stalking injunction. These statements, some were made while he was employed, some were made thereafter. It happened in roughly June, July, August of this period. And then they hired a law firm who investigated it for months, got every bit of dirt they could get on him, and 2 months later, they file an 8 cause of action complaint along with an ex parte civil stalking injunction. This is a tool of litigation in civil litigation, and it shouldn't be used that way. That's how it was done here. And that's a problem, because if you start to look at the broader implications of this, you're going to have, when somebody is fired and they say, I have a claim against this company, and I have dirt on this company, I'm gonna be a whistleblower, and I have dirt on this company. Now, what you do is, if they say that to two or more people, any way affiliated with that company, not even the protected individual, the specific individual, but anyone affiliated with that company in a closely held business, there can be a civil stalking injunction against them. That's a big problem. That's a huge hole in the jurisprudence. And so ultimately, I think, and these aren't the only options, but I think these are the primary options before the court.
Your hypothetical about you send the mean letter, lawyers send demand letters all the time. We have a lot of case law dating back decades that says those are protected by the judicial proceedings privilege. And I don't know that we have a case that says civil stalking comes within the judicial proceedings privilege, like we have one on defamation and intentional interference and intentional infliction of emotional distress. There's these cases that sort of expanded the scope of that privilege over time, and I don't know that we have one on civil stalking, but it seems like it
does
should.
seem like it should. And you know, I think that there's some options here. Number one is this court could reverse on this specific individual application here. That the court was looking at the specific, where it said it was aimed at TKS. Now there's some mix in the ruling, and I concede that the court could have interpreted things aimed at TKS to be aimed at Troy.
Because I think we have to interpret the statute broadly enough to account for Judge Luthie's hypothetical, right? About the piano teacher whose ex-boyfriend is
Sure.
stalking her by telling her piano customers that that she's a bad person.
Yeah.
Right?
Yeah, I think that's okay, but it's not it depends on, I mean, I think there's some concern in saying that people cannot communicate with others. Now, that would certainly be a viable claim of economic interference or a viable claim of slander, but that's different than causing emotional distress. You know, if we're going to set the bar for emotional distress so low that it is a loss of customers or a potential civil liability, that's a really low bar. And the world is full of threats from one another, and you know, and whenever there's a threat of wrongdoing, that cannot be emotional distress. Like, something that you don't like cannot be emotional distress. There are other ways to deal with that, and it's not through the civil stalking injunction. Now, the second option that I think this court had,
Oh, go ahead.
is this court could reverse on the grounds that threats of civil liability do not constitute emotional distress under the stalking statute. And I think that's fair here. And then the last item is this court could affirm. But if this court were to affirm, I do think it opens a floodgate of potential litigation tactics. It would create an incentive for parties when they are threatened with employee dismissal lawsuits to get civil stalking injunctions against those employees. Non-solicitation issues. They could do investigations to try to get civil stalking injunctions against people leaving companies to prevent them from soliciting employees in almost a forced judicial restraint matter, where not judicial restraint in the sense that of activism, but more judicial restraint in the sense that they are restraining people from contacting other customers and the employees of the company. You know, this has some really broad-reaching implications.
Before you sit down, Mr. Brammer, I'd like
Yes.
to talk to you for a few minutes about the timeliness of your appeal.
Yes.
It doesn't seem to me that your appeal can fairly be categorized as a cross appeal. And the reason I say that is because the contempt proceedings are separate from the original entry of the stalking injunction and the dismissal of the underlying actions. I mean, think about a divorce case, right? We enter a divorce decree, that gets entered and it's final. And then whether somebody failed to pay child support down the road is a completely separate proceeding, and that's separately appealable and through an order to show cause, and we have contempt proceedings. So those are treated as separate appellate proceedings. So it seems to me what we have here is two separate appellate proceedings. They're appealing the contempt order, and you're appealing the underlying entry of the stalking injunction. The timeliness of it here is tricky. Your appeal, if it's timely, doesn't seem to me, and I'll just tell you what I'm thinking and you can respond. If your appeal is timely, it isn't because you filed it within 14 days of their appeal. If your appeal is timely, it's because this order that got entered on September 14th is not 58A compliant, and that gives you another 150 days to appeal. And if that's true, then your appeal is timely, but not as a cross appeal, but just as a separate appeal.
And if this, and that was somewhat brought up by the court sua sponte. And, you know, number one, I don't think that order was 58A compliant. It simply does not meet the Griffin standard.
And tell me why you think so.
Because it doesn't resolve the issues as a judgment. It doesn't have, Rule 50, or the Griffin decision talked about how it has to be set forth in a separate document different from an order. It has to deal with the parties' liabilities back and forth. It was not a judgment of the court. It was an order.
Any order that starts, this case came on for hearing on July 13th, 2021 on, one, the motion to dismiss, and two, respondent's motion to dismiss. Any order that starts out that way seems to me is almost presumptively not 58A compliant. It's talking to us about what happened in court on July 13th. It's not a separate document telling us, hey, this case is over.
Yeah, and it was very similar to what happened in Griffin. In Griffin, there was an order dismissing the case, and there was an argument that the appeal wasn't timely. And the court said, we had all these confusions prior to Rule 58A's amendment, and now we're trying to clarify that. It says it has to be a separate document. It has to be clear as to the parties' liabilities. And what we're going to end up with if something like this is not found to be timely is we're going to end up going back to what was called the practice of protective appeals, and keeping watch at the office of the clerk, meaning everybody after every order is filing a notice of appeal. What we're trying to do is let's wait till the case is really over and then we'll file the appeal. And whether we call it a cross appeal or an original appeal, I think is a distinction without a difference.
Well,
we're happy to do it either way.
If your appeal is timely, it is a distinction without a difference. I agree with that. But let me ask you one more question.
Yeah.
What makes this order potentially different from the one in Griffin is paragraph 4. That's, apparently you all negotiated this via email. They put some of these emails attached to their brief. With Claim 8 having resulted in the issuance of the stalking injunction and respondent having previously dismissed his counterclaim, all claims in this case have now been resolved. So this order does make at least some effort to say, hey, we're done here. The order in Griffin, I'm not sure, it just resolved the pending motion, which happened to resolve the last claim, but it didn't really go this step further. What do you make of that?
Well, there may be orders that have almost a substantially identical effect to what a judgment does. However, Rule 58A is quite specific that it needs to be a separate document that is labeled as such so that the parties can be clear as to when deadlines run. And so the mere fact that it has substantially an identical, any granting of a summary judgment motion has, can dispose of the entire case, but it is not a judgment per se. We've said this is how we're defining judgment. It has to be defined, and it's a separate document from an order. And so it still would require something to let the parties know this is the judgment in the case, or 150 days.
Thank you.
Thank you.
I'll first address the issue of whether a business can be the conduct of stalking. We spent a lot of time on 76.506.52 and the directed at language there and the individual language there. I think the analysis needs to also include 76.506.5 1A1 in the definition of course of conduct, which says that the acts which can comprise a course of conduct include those acts in which the actor interferes with an individual's property. And our contention here has always been that TKS, because of Troy's ownership, was Troy's property, and that therefore attempts to interfere with TKS to the extent they rise to the level of stalking were the prompters.
Can I get your thoughts on the mootness question on this issue? This stalking injunction is going to expire in 6.5 or so weeks. Mr. Brammer says, well, that doesn't render the appeal moot because we have some ancillary or corollary consequences. Can I, none of that was briefed.
Right.
So
Mootness wasn't briefed.
I don't have your thoughts on this.
Well, our thought was this, mootness happens when a decision cannot affect the rights of the parties. I think if the injunction expires on its own terms in 6 weeks, it would be difficult for this court's decision to impact the rights of the parties, at least those rights that relate to the injunction itself.
Well, what do you make of his argument that there's an attorney's fees component to this and some other I guess, some other ancillary consequences that were visited upon Doug.
Well, I mean, certainly there were consequences. I mean, that's always the case in case of a stalking injunction, but that seems pretty remote and speculative to suggest that this trial court judge is going to award fees. We in fact filed a motion for fees, which was our right, and the court denied it and said, my basic philosophy is not to award fees in these types of matters. So that's there in the record. I guess, yeah. Let me make sure I understand the court's question. Is the court asking whether both appeals would be mooted with the expiration of the stalking
I
injunction?
don't think there's any suggestion that your appeal
Okay,
would be mooted. The contempt appeal.
okay. I just wanted to make sure
By
I understood the full
expiration
scope
of the order. I mean, you're saying the order was violated during the period in which it was robust.
Right, okay. I think the court should be careful to not read all of Doug's statements and threats, particularly those that were shared with Sarah Wilson, that formed part of the basis of the trial court's entry of the initial stalking injunction as directed solely at his family. I mean, Doug was making statements about his plans to ruin Troy, to have him and his family out on the street. I don't think we heard the full universe of the statements.
Now you got me thinking about mootness here, sort of on the fly. And again, I get that you guys. I think the reason this wasn't briefed, honestly, is that these briefs were filed about a year ago, and at that point, mootness wasn't really on the brain because you still had a year plus of time under the order. But the appellate wheels grind more slowly than
Sure.
we would like sometimes, and so that's why we're facing this issue. But I guess my question to you is, doesn't the mere presence of your appeal render theirs not moot? In other words, if you're asking for contempt under the order, it matters whether the order should have been entered in the first place, right?
Well, I don't think that's one of the elements that the court typically looks at in its contempt jurisprudence. Not whether the order that they're in violation of was properly entered, but rather whether they knew what was expected, had the ability to comply, et cetera. So I think that would read an extra element into.
I don't think you're tracking my question, right? So I'm trying to figure out if their appeal of the underlying stalking injunction is going to be mooted by its expiration here in 6 weeks.
Right. And you're asking whether the existence of my appeal colors
Yeah,
the
in other words,
analysis
if they're right, that there never should have been a stalking injunction in the first place, then your client
Has no appeal.
there's no way you can be held in contempt of an order that we're going to vacate.
Sure.
Right, so maybe that answers the mootness question by the fact that you're standing here. No, I mean, am I wrong I'm just thinking out loud. I honestly don't know the answer to the question I just posed.
I don't know the answer either.
Okay.
It seemed, as I was trying to say, I think that generally contempt proceedings are not viewed as an opportunity to collaterally attack the underlying order, and so
This
that's.
is also true, but that goes to their appellate, that goes to the timeliness of their appeal, which I'd love your thoughts on as well.
Well, I mean, what I would say there is, the language in the second half of the order was included at Mr. Brammer's request.
You're talking about paragraph 4, the one I read?
Yeah, the one that you read. I mean, and I agreed it was a good idea. I think in part because, and I don't want to overstate the case here, but I think I did have Rule 58A concerns lurking in the back of my head, so I thought it was a good idea for us to have an order that stated definitively, we're done. This is all of the causes of action which were brought in these proceedings have now been resolved, either through dismissal or through the entry of the stalking injunction. So I agree that it does not contain the title judgment. So it's somewhere between the precedent we've been discussing. This is not an order that is completely oblivious to the other causes of action, what's happened with them. It attempts in its own terms to give an overall statement of the resolution of all causes of action, but it doesn't contain the word judgment. So
Do
I
you,
think.
do you also agree that it's not a separate document? There's no other document that it would be separate to?
I think I have to concede that, yes, there's no separate document, yeah. Yeah. All right, I see my time is up. My partner handed me a quick note, if I could, just really quickly, remind the court of its recent ruling in Commercial Club, that says, without insight into the district court's reasoning, we're unable to ascertain whether the district court's decision follows logically from and is supported by the evidence. That's generally our concern with some of the findings made in the order denying the motion for contempt.
Thank you.
I'd like to address two things and then any questions that you have. The first is to follow up on the issue of mootness. I think if this court were to find that it were moot, I think there's a concern with people just running out the clock. And you're gonna have a whole lot more interlocutory appeals on that type of decision, on any type of civil stalking injunction, in order to avoid having the appeal,
Well, this is exactly the issue we have in the bail context right now, and that's why there's an interlocutory appeal statute in the bail context, and that's why we put an expedited process for bail appeals, because people do take pleas and sort of render that moot. I mean, that shows up in all kinds of areas of the law.
Yeah, and there are some statutory penalties, and I do think that the fact that they're, what you talked about with, we have to address their claim of contempt if we're appealing on the basis of, we don't think that it should have been granted in the first place. I think that is an issue that needs to be addressed. Now, the second issue that I did want to discuss briefly on the contempt matter, Ragsdale also addressed the issue.
Is that beyond the scope of the cross appeal?
I think that, I guess I'm trying to understand if you wanted the original argument to address their stuff or the response to address their stuff.
Your rebuttal, at this point, you usually wouldn't be up here now. You're up here now
Yeah.
because you have the opportunity to rebut his arguments relative to the cross appeal.
Yeah, and I didn't hear.
And I don't know that includes contempt. Your cross appeal had to do with the validity
Sure.
of the underlying.
Sure.
Or-
So I'll leave that to the side. What I would say is, with regards to the issue of the reasonable person standard, I think that this court has some pretty tough decisions in front of it, as this case puts some issues before the court on the statutory interpretation, but even if not, on helping to define the reasonable person standard. Because really, there are no threats of personal violence against Troy. None of these statements were made to Troy. None of the court did not find any type of threat to his person. And then the idea that it includes property, what that typically means is, does someone go and key another person's car in a civil stalking context? It's not, if you're going to include corporate ownership in property, then that Elon Musk idea comes up. And I think that the idea that you have animus towards someone, so you're going to bring civil liability action against them to hurt them, is that enough for emotional distress under the civil stalking injunction? Or is it better to leave that to the typical civil litigation mechanisms, which would include a Rule 65A injunction? It would include, suing them for, tortious interference, things like that.
Would it be fact specific to the individual case? Elon Musk is in a different position financially than some other folks, and Elon Musk getting threatened with a lawsuit from some random customer, we'd look at that specific person in Elon Musk's situation. Would they feel emotional distress versus someone who has a shoestring business and is being threatened to be sued about that. Certainly, I've had clients where any threat of litigation or actual litigation does cause substantial emotional distress in reality. Do we not leave that to the fact finder, given the individualized circumstance?
I think this court would have to be very careful in doing that, and the reason why I say that is if this court is going to say that now there is a means test with regards to threats of civil liability resulting in emotional distress under the stalking statute, that puts every small business, that puts every closely held business into the crosshairs of use of the civil stalking injunction to prevent civil claims coming against them preemptively. And it becomes a litigation tool in the civil context. There are lots of other tools that we have in our code and in our rules that allow us to address those types of proceedings. But part of the reason why the legislature said specific individual and the individual's own, stuff is.
So maybe ending
is
with
tied
my
to that.
first hypothetical,
Yeah,
would that leave the girlfriend with a piano lesson business unprotected in this circumstance? That if the threat was that the ex-boyfriend says to the sister, I'm going to ruin her.
it certainly
And-
would not. And the reason why I say that is the civil stalking, it would leave them unprotected for use of the civil stalking injunction if they're never contacting her or anything like that. But if it's simply going after business, she's protected under other measures. She could file a Rule 65A injunction saying this will result in irreparable harm. She could file suit saying you're interfering with economic relations. Those are all the tools that we use to deal with economic loss. The civil stalking is meant to be something a little different, and it's individualized between people. And so I think that she's not unprotected, she's just not protected by this statute.
Thanks.
Thank you.
Thank you for your arguments. They've been helpful. This is an involved case. We'll give it the consideration it's due and render an opinion as soon as we're able. Thank you.
Thank you.